afternoon, good evening to you, wherever you're joining us from. This is yet again another exciting Africa Digital Rights Hub webinar. The Africa Digital Rights Hub, as part of our advocacy, awareness creation, and capacity building program, has been using our online channels to engage subject matter experts to educate and create the much needed practical understanding of critical issues around digital rights and technology on the continent of Africa. Today, we are very excited. We will be discussing techpreneurship and intellectual property in Africa. And we have been joined by two eminent experts on the subject, one from academia and the other from a regulatory body. Many African countries are yet to fully establish, implement, and efficiently enforce laws on intellectual property. It has been perceived that the lack of effective IP laws on the continent impacts its innovation in the tech space. This webinar therefore seeks to examine and demystify the intellectual property laws and issues in the context of technological development and innovation in Africa. We will explore the conduciveness or otherwise of our IP laws in the continent's budding technology industry and what techpreneurs must do to enjoy such rights. And I must say I'm extremely excited because of the speakers we have today. By the way in which they will speak, we have Professor Ruth Okedeji. Professor Ruth Okedeji is the Jeremiah Smith Jr. Professor of Law at Harvard School and the co-director of the Beckman Klein Center at Harvard University. She is also a director of the Global Access in Action program at Harvard, where she focuses on intellectual property law reform and public health in sub-Saharan Africa. She teaches courses in contracts, in patents, copyright law and development, and biblical law. Prof, I really wish we would have another time to talk about biblical law, but that sounds so exciting to me. As a renowned scholar in international IP law, international trade, and the digital economy, Prof. Okedeji has advised many intergovernmental organizations development. Her widely cited research and scholarship on IP and development has influenced government policies on patent laws and access to pharmaceutical products in sub-Saharan Africa, the Caribbean, Latin America, and Southern America. Prof works closely with several UN agencies, research centers, and international organizations on the human development effects of international IP policy, including access to knowledge, access to essential medicines, innovation in Africa, and issues relating to competition law and indigenous innovation systems. Prof is also an editor of the Journal of the World Intellectual Property Law and an elected member of the American Law Institute. She is the recipient of numerous awards for excellence in teaching, research, and mentoring, including the 2017 and 2018 recipient of the Shatter the Ceiling Award at Harvard Law School and the 2019 IP3 Award by Public Knowledge. Prof is no doubt a recognized influencer in IP law. she has been recognized by Managing IP as the world's 50 influential leaders in IP. And you would agree with me that Prof is indeed a great resource for our continent of Africa. And we're extremely pleased to have you with us this afternoon, Prof. Thank you and welcome on doing this. We couldn't have had you at a better time than this.
Thank you so much, Techie. That was overly generous and overly long.
Thank you, Prof. Our second speaker is joining us. She is working in the regulator's office, and Dorothy is a senior state attorney with the Ministry of Justice in Ghana. She was called to the Nigerian bar in 2004 and in 2007, and she was also called to the Ghanaian bar. She has worked with the Copyright Office in Accra from 2007 to date. Dorothy was the chairperson for the copyright monitoring team in Ghana. Dorothy has also been influential in drafting Ghana's IP policy, as well as the constitutions for the Ghana Actors Guild and the Ghana Music Rights Association. Each of the speakers today, so welcome, Dorothy. I don't know if you can hear us now. Can you? We're still having a few technical glitches with Dorothy, but she will be joining us once that is sorted out. Each of our speakers this afternoon are going to give us a short presentation of about 10 to 15 minutes on today's topic, and we will then follow up with your questions and comments to get better insight into their presentations. Meanwhile, I just want to notify all of you that we have a poll running, and we'll encourage all our participants to respond to the poll. I will come in 30 minutes to the end of this event to announce the poll results. And so without much ado, I will just at this point hand over to Prof to tell us a bit more about our topic this afternoon. Prof, you have the floor now. Thank you.
Thank you so much. It's such a delight to be on the continent and virtually, even if it's just virtually. Let me say that I am missing my fried plantain and my fufu, and I've been in Accra doing this. I want to really honor the entrepreneurs and the innovators that are in the audience, and lawyers in particular. But really, I want to give a special shout out to our innovators. I have said and will continue to say that African innovators and innovators in Africa are the least appreciated, least recognized, least honored group on the continent, especially in sub-Saharan Africa. And the continent owes you a lot. And I'm hopeful that events like this will keep the conversation alive and enable and encourage and inspire policymakers to be tenacious, to be insistent about the kinds of laws and the kinds of initiatives that are necessary to make sure that Africa takes its place in the innovation landscape, and that African innovators are really highlighted for their contributions not only to the sustainability of life and society in Africa, but also, frankly, the global innovation landscape as well. I have some slides because I find that these tend to be helpful, especially to the audience, and I thought that we should just go ahead and use these slides, and I will attempt to share my screen, see if I can do that. Can you see slides, Techie? Techie, can you see?
Not at the moment. Not
okay, give me a minute. Let me share my screen, and then you should be able to see it. All right, can you see the slides now?
Yes, I can.
Okay, wonderful. Okay, so for those of you who are, technology enthusiasts and who have studied technology in Africa, you will know that innovation in Africa has been a persistent part of the economic and social landscape. Although this is not a narrative that you will find in the popular literature, it's also not a narrative that many in sub-Saharan Africa really engage with intentionally. Clapperton Chakanetsa, who is down the street from me in MIT, really puts, I guess, words to what I think is an important point. The idea that technology can only come from outside Africa, the idea that the only important or impactful technology comes from labs and factories outside of the continent, is not only troubling to Chakanetsa, but also, frankly, something that I have written about for many, many years. The reality is that prior to the colonial encounter and even after it, innovation in architecture, in herbal medicines, in metalworking, in astronomy, in agriculture, sustained the life and the well-being of many African economies. In fact, the griots that were developed for record-keeping systems, for recording births and deaths and life, still continue in modified forms today. And the real challenge, of course, for the African economy and for the African society is that the scalability of innovation in sub-Saharan Africa is really challenging. The importance behind accelerating and finding ways to solve local problems is the responsibility and the opportunity for innovators in African society. Young Africans every day, everywhere, in every sector are unleashing significant entrepreneurial energies, even though the legal framework may be deficient. Governments are trying to enact reforms that improve business environments, but as we all know, the pace of legal reform almost always consistently lacks and is slower than the pace of innovation. This is actually true not only in sub-Saharan Africa, but is true really in countries around the world. The law rarely leads technology. Technology almost always leads the law. And as a result, we're seeing that notwithstanding the absence of formal regulatory frameworks, that there are numerous startups in Kenya, in Lagos, in Accra, in South Africa, all over the sub-Saharan part of the continent. We are seeing startups yearly increase in terms of number. We're seeing a variety and a diversity of innovation to address particular needs within the African economy. We're also seeing deepening competitive capacity, which means that there is hope for the future. If we make certain intentional steps, there's hope for the future beyond minerals and hydrocarbon, which is what African economies have subsided on for many, many years. And so when it comes to what are the challenges, how do you scale innovation? Because for the pre-colonial and post-colonial innovators, innovation has always addressed local problems. Innovation has tended to respond to immediate needs without the sense of commercialization and without any real formal channels to push the technology to reach the broader society. There is a limited capacity for scalable products. And that means that getting into the innovation economy, as opposed to just being innovative, has been a challenge. Getting into the innovation economy with competitive local services and products has remained problematic for many techpreneurs. And so if you think about, for example, in Zimbabwe and in Mozambique, the way that indigenous hunters made tools to hunt and to kill game, the ways in which there was an identification of shooting and trapping and other weaponry that was trained children in the art of survival. The ways in which our trees were used to manufacture medicines and even poison for purposes of addressing risks to the well-being of the society. These are examples of innovations that now have paved the way in many ways for the innovation that we're seeing in the era of COVID-19. COVID-19, as we know, has underscored the importance of using technology in healthcare, and we see innovations coming from sub-Saharan Africa. And on the slide in front of you, I just want you to note the various hotspots that we see in terms of just sheer number. This is being tracked on a daily basis. Sheer numbers of innovation to address prevention, diagnostics, and treatment of the pandemic. We have track and trace tools and software programs and information dissemination innovations coming out of various countries in sub-Saharan Africa. Very few countries are inactive in the innovation front. So there's a lot of activity we see from our innovators, but those activities often are not coalescing, nor are they being propelled by an intentional policy framework, and they're not being supported by laws that would facilitate integration into the global economic scheme. Africa is still deeply underperforming in core areas that are needed to redesign its economies and to make the economies more sustainable. There is still significant challenge by factors that indirectly or directly inhibit access to capital. We have significant challenges with our intellectual property system, and obviously difficulty with energy and energy sources and inadequate infrastructure. But if you look at the innovation clusters on the continent, it's really quite striking to see in the midst of the challenges to scalable innovation, we are seeing the persistence of innovation activity, creating clusters in places like Nairobi and Kigali and Accra. We see this in information and communications technologies. We see this in local craft. We see this in healthcare and medicine. And of course, we see this in engineering and science. And so part of the challenge, of course, is the need to find ways to scale the innovation, particularly in COVID-19, for example, given the rate of innovation that's happening, to scale that innovation and in fact to contribute it to the global innovation system where there is a race for a cure for COVID-19. So what do we do? There is a role for intellectual property rights. Many of you are intellectual property lawyers or scholars, and you know already that a patent is a limited monopoly that is given to protect an invention, to encourage that invention to be disclosed to the public for use. The entire policy animus behind IP rights is the public welfare. It's society. Copyright, of course, protects works of authorship, including software, which many of the innovations that we are seeing coming out of Africa really relate to software. And a trademark, of course, is the branding mechanism. It allows a consumer to know the source of the technology or the source of the service that he or she is operating in. So when you think about the digital economy, Africa in many ways is better positioned for innovation in the digital economy, much more than it was for innovation in the industrial age. In the innovation system, and I know that our other speaker, Dorothy, will speak to this, in the digital economy, copyright has played a much larger role in protecting and enabling technologies to be scaled, even technologies within the African landscape. What is critical to note about the digital economy and innovation that is digital in particular is that the system for dissemination of that innovation relies on business models that really anchor in some form of IP right. The business model is more important in economic terms than the copyright protection, but the business model would not flourish without adequate IP protection where limited, where available. And so this means that we have some work to do on the African continent. Intellectual property rights can be used to protect technology. They can be used to protect the brand name, the design, and the creativity behind the concept. It gives the creator ownership rights. And many times venture capitalists are looking for that exclusive ownership in order to invest and to secure their investment fiscally, financially into the technologies. And of course, owners of the IP right can then control the use of the technology and continue to invest in improving in that technology. There's something else about intellectual property rights that innovators need to be aware of. You may not need the intellectual property right per se, because obviously in the African context, you have innovated without it. But intellectual property rights often have other kinds of functions. For example, they signal to a competitor that if they want to utilize your innovation in their improvement, they need to license and provide some sort of remuneration to you, the owner of the original IP. It also signals value to investors. So you are in Accra, or you are in Kigali, or you are in Nairobi, and you're creating code that you know is going to be significant and that might find significant commercializable value. How do you attract private investors? An IP right often is one of the tools in your toolkit to signal value to potential investors. It means that the IP right allows you to access knowledge markets. It allows you to access networks. It prevents rivals from stealing your idea, stealing your innovation, and robbing you of the right to returns. And so when you think about the two main categories of intellectual property, in both of these categories, industrial property, which is patents and trademarks, industrial designs and geographic indications, and copyright, which deals with literary and artistic works, including software, you see that the sub-Saharan continent is still dealing very, very in rudimentary terms, in very limited terms. Innovators in Africa do not have sufficient access to capacity building and reinforcement of their investment in innovation. For example, when you look at the statistics, the member states of ARIPO, who account for about 56% of the population and 60% of the economic activity in the continent, are still not representing the significant amounts of innovation that is occurring in the continent. In other words, what's being registered at ARIPO does not match the rate of innovation that we're seeing in ARIPO member countries. What's also interesting, of course, is that there are very few countries in sub-Saharan Africa that actually have independent national patent offices. And of course, those patent offices, less than 5% of them have the capacity to actually examine patents. Many of the patent offices simply register the patents without doing the work of examination, which means a foreign inventor could obtain a patent in Ghana for which a Ghanaian innovator has been investing funds and investing capital and investing energy. And yet, because there's no examination, you create a competing and a conflicting ownership situation in which the local innovator, maybe because of lack of funding, did not file for the patent, maybe because of lack of know-how, didn't file for the patent. But in any event, you can get foreign inventors who may see the innovation of African innovators and then go and obtain the IP interest either on the continent or in fact outside the continent. This is really a problem. The lack of a single regional office, like many Francophone countries, sub-Saharan Africa did not ever establish registration systems for copyright. which means that it is very difficult for software developers, for example, to register a copyright interest. We have not developed systems to allow copyright owners to have a tangible manifestation of their ownership stake, which means that they are relying on the very thing that IP was created to avoid. They're relying on trade secrets. In other words, many innovators devote a lot of time to hiding their innovation in sub-Saharan Africa because they're afraid it's going to be stolen. They rely on lengthy processes involving other kinds of security measures. Why? Because of a concern that their IP and their innovation will be stolen before it's perfected. The other big issue, of course, is the last bullet point you see there, is that filing for IP protection is expensive and it's a lengthy process. And for many, many innovators on the continent, they don't have the time, they don't have the resources, and in many ways, they don't have the know-how to even take advantage of the systems that exist on the sub-Saharan arena. Let me also just add to this something that has concerned me. Because of the digital economy and because of the pandemic, many innovators are displaying their innovation in the process of programs such as this. They show their innovation, they discuss it via Zoom or Hop-in or Facebook or FaceTime. They display their innovation many times to attract interest and to attract capital investments. But many of our innovators do not understand that by so doing, they are exposing their innovation to other innovators outside the continent who may have better regulations and better systems, and so can take those ideas and those innovations and go and get a patent or a copyright or trademark in other countries. So it's a situation in which African innovators, frankly, are facing the worst of both worlds. They don't have the capacity, the know-how, or the time to utilize any available, if they're available, IP protections on the continent, and yet they're forced to display their innovation in order to attract capital, which means that they risk loss of those innovations to outsiders who may then go and get the innovation in their own countries. And this, of course, is a problem. The lack of regional offices and institutions to support innovators means that we have an inability to scale up, and it means that our innovators are really at a global disadvantage. Of course, there are other things. My time is up, and I want to just mention a few things that are gaps, because Techie asked me to identify gaps in our current regulatory framework. Outside of South Africa, there are severe gaps in intellectual property and privacy law. I have been looking at the curriculum of many law schools in sub-Saharan Africa, and I have yet to see a consistent curriculum. In fact, most of the curricula do not indicate any course whatsoever in privacy and surveillance law. This is really, really problematic. For example, in Tanzania, there is no law that restricts the processing of data outside of Tanzania, even though the security of that data and that data itself belongs to individuals who are citizens in Tanzania. Basically, in Tanzania, data security is individually managed by company policies and guidelines. And this is, of course, a problem because in the digital economy, and particularly in a lockdown, people have to disclose their data in order to get many kinds of services. Another example is Nigeria, where essentially the country has enacted sector-specific laws that have data and privacy protection provisions. And even though you have a fundamental right to privacy in the Nigerian constitution, there has been no regulation for children, for the protection of children. There's been no regulation for banking data, for credit data, for cyber crimes. And this is, of course, a significant challenge in Nigeria and many other countries. Kenya also, for example, is adopting a comprehensive data protection act. But again, it is important to note that the newly established Office of Data Protection is not yet financially independent to make the new law operative within Kenya. So it's critical that these gaps be addressed. because innovators are going to have to use data. They're going to have to deal with privacy concerns for consumers. And here we have laws on the ground that are already enacted by our policymakers, but we don't have the parallel regulatory framework for enforcement. We don't have lawyers that have been trained in privacy or surveillance law. We don't have innovators that are being supported and who can even afford access to the IP rights that would enable them to take advantage of these laws where they exist. The other thing that I want to quickly mention and then stop speaking is that Africa is often the testing ground for technologies that are developed elsewhere. It means that many times sub-Saharan African citizens are giving up biodata with very little understanding of what they're giving up, very little understanding of what their rights are. Many African countries are now requiring citizens to register biodata, to get healthcare, to vote, to get other forms of public assistance, sometimes even to use the internet. In an internet cafe, you have to have an iris scan or a facial image scan. These are all sources of data that are then exploited and sold to third parties for commercial or political use. Yet we have innovators in sub-Saharan Africa who are innovating around data storage, data privacy, data protection, and yet there is no correlation between what citizens are being asked to do, what innovators can help us with, and the set of laws that exist on the books. Now, here's where things become very concerning for me as a scholar and as an expert in this field. Many African governments are stepping up the surveillance of their own people. Uganda has the surveillance program, Nigeria, South Africa. What's challenging, of course, is many of the technologies for surveillance and the contracts to do the surveillance are by outsiders. So even if you wanted to bring a lawsuit on the basis of the Ghanaian constitution or the Kenyan constitution, it will be difficult to get jurisdiction over a foreign data service provider located in the UK with whom the government has contracted. So a few recommendations. Lawyers have a lot of work to do. We need to see upgraded curriculum. We need to begin training the next generation and even this generation of lawyers, either through specialized programs, through webinars such as this about privacy law, surveillance law. We need to begin as a continent to think about equipping lawyers to do the work for innovators that are on the continent. Second, I want to also say that I'm a little concerned about the lack of commercial laws that are being upgraded to reflect the current innovation that is occurring. For example, contract law that is used to keep a trade secret, contract laws such as non-disclosure agreements. We don't have jurisprudence on law and technology in the continent. This is going to be a problem because it means that our courts are not yet equipped and have not yet had the exposure to the many legal issues that innovation is bringing to the forefront. There's a robust need for information and privacy laws. There's a robust need to empower citizens to set the norms for what technology can and cannot do in our sub-Saharan economy today. And with that, let me return the floor to Techie. I apologize that I exceeded my time by about 5 minutes.
Oh my, Prof, I am so excited. You've raised so many issues, and I must confess, even though I have been in the privacy and data protection space, I never really, looked at the link between intellectual property and privacy and surveillance. And it's very interesting to bring this up. I will now just hand over to Dorothy to share with us her own experience around the topic, what they've been facing, how the Ghana Copyright Office have been encouraging innovation and dealing with some of the challenges that have already been highlighted. Indeed, it's very interesting to note that there are a lot of questions already flowing. So please keep your questions coming in. After Dorothy speaks, I will throw your questions back to our eminent panelists. So Dorothy, over to you now. Dorothy,
Hi,
can you hear me? Great. Okay,
yes,
great.
thank you.
Yeah.
Awesome.
Yes, we can.
Yes, I've been very much enjoying this. These are real, and them all, and then probably so that I throw more light a bit on the with one to action degree or the degree that I do in my presentation or my talk. If is the creation like as mentioned, I aspect and I noticed the industrial property aspect and the copyright. Industrial property, like she covers geographical indication. It deals with a small patent. We also have too much of that. And then we also aspect of IP covers physical work, computer software, you are more conversant or involved with. That also deals with work, artistic works, audiovisual works. All of those fall under copyright. You would right now on the protection of creators, because inventors relate more to it or the creative aspects of intellectual property. The criteria for eligibility must be the work must be on a fixed medium. It must be created by the citizen of the country. So is to be protected, or must have residents in that eligible for protection. That are not protected under concepts, ideas. Have an idea and it's been expressed in a way, it's in copyright. Right, so we have the economic rights. The rights of an author or creator to make things from the work he or she rights is the that work is used or as to the rule exceptions in order to the copyright would be used if you get maybe you buy a musical work and you listen privately in residence or permission to use that work. Also, if you are using the work for an enactment, if it was a court process, or the report of the commission or of the inquiry. You don't need the authors to use. So you can use them in this way without permission necessarily from the creator of the work. Now, there are ways of transferring it. You can transfer it in will. And the in copyright, or the way to transfer your digital rights, one is an outright sale. You create something, you feel that you are, and you just want to make money from it. You don't want any further interactions with it. You can do that by assignment. Licensing also, you could give the right use, especially software for a particular subject, or what you could, so that once that use is back to you, yeah, and then you also can transfer rights through testamentary possession. So you assign, and then an operation of it. We need it for public use, for emergency situation. That material is needed to solve an economic or any permission of the owner. It's between 50, that says 50, but some countries have been able to 7 lifetime of author after his death, or 50, depending on the jurisdiction you are in. So some jurisdictions would have 50 as much as. Basically, that copyright works, which are works to the domain of public, are available for use. And such works are works probably that so works for have renounced their rights to, or for enjoy protection. Those works will be used without from the old some restrictions. Copyright has registration. That's not jurisdictions. So there are very few countries who copyright. You need to work you're in that work. So, of the copyright to bring your works for you, and the is actually to keep for litigation purposes when the case is within the jurisdiction in which they are registered. So you don't, in all jurisdictions, you can prove your copyright. This is where it works in ways that infringe on the in our work exclusive of the stream. And so communication to the public, right? Of copyright, for which if one uses every jurisdiction, but then the subject or to formulate but you can go and see, and then we also so a work has been infringed, one could apply copyright depending on systems operates. Go through the copyright of the initiated in Ghana, for example, within the office. Then we could go take the matter of get an action within to two ways that can go by civil. The remedies could be or down depending on the particular issue. Could be by way of fine. You could go or the issue resolved. That would cover protect in regards to framework in this regard. I don't know. I'll just wait for to expand on the issues elaborated so far, if that's okay.
Very well. Thank you, Dorothy.
So
Prof, can you hear me? Dorothy, can you hear me? Great. Okay. So there are a few questions that I'm going to ask. I think there are a lot of questions coming in. I'm going to ask the first three, and then you can all, respond to it, or if you feel that you do not have expertise to respond, you just let us know. The first question is asking about IP protection in a scenario where you have, for instance, a Delaware-based holding company and local operating entities in Africa. How should you approach your IP protection? So that is the first question that we got in. If you have a Delaware-based, for instance, or US-based holding company and local operating entities in an African country, then how do you attempt, or how can you approach IP protection? The other second question that we have is saying innovation, especially in the software space, can be primary or secondary. Most of the softwares we build rely on underlying technology, say from Google or Amazon. How do we go about IP protection in such a scenario? And then the third question is, how do we balance the privacy concerns and the need to drive development via innovation? One is looking at setting up with their leg in Africa, and another in elsewhere, particularly in the US. And how does such a company attempt protection? The second one is looking at innovation, especially where they build on existing platforms such as Google and Amazon. How do they approach protection in those cases? Then the third question is balance between privacy concerns and the drive for innovation and development. Prof, do you want to?
Sure.
react to
Sure,
those
I'm happy
questions?
to, and I think Dorothy is the real expert here, so I want to make sure that we give Dorothy an opportunity to respond. So let me start first with what every good lawyer, as Dorothy will tell you, every good lawyer has to say, which is, I am not licensed in Ghana. I am not a Ghanaian lawyer. So everything I say, if you take it as legal advice, you will get a bill from me. So if you're not paying for this, it is not legal advice. Okay. So let me just speak more generally, and I see that this is from someone in the audience. So first of all, there is no such thing as an international patent. There is no such thing as an international copyright, and there is no such thing as an international trademark. So just put that down in your notebooks or in your minds or on your little iPads. In order to get intellectual property protection, you must comply with the national obligations in every country in which you want to assert the intellectual property right. What exists is an international framework that more or less harmonizes the basic criteria for a patent, for a trademark, and for a copyright. So for example, if you were to obtain a patent in Ghana, the Ghanaian requirements for patentability are going to look exactly on paper like the Nigerian requirements for patentability, like the South African requirements, like the American, the Chinese, the German. So on paper, every national IP law looks the same. The same obligations of, for example, originality and fixation when it comes to copyright, the same patentability criteria of novelty, inventiveness, right? Industrial applicability. They're all the same globally. That's because to be a member of the World Trade Organization, every country had to agree to the same legal standards for each category of IP. So that's the rule. The rule is that you have an international framework that harmonizes all of the criteria for intellectual property, country by country, but the application of that criteria, the interpretation of those standards are left to local courts and local institutions. So when I teach, for example, I always show my students an example of a patent that was applied for in the United States, where several of the claims were denied by the US Patent Office. But those same claims may have been accepted in Japan. Those same claims may have been accepted in Germany. So each country, even though the law looks the same, the interpretation and the application of that law is dependent on the local offices, the local intellectual property offices, and the courts. This is a very important thing, which is why Africa is so vital that African courts and African IP offices develop a jurisprudence that is meaningful to African innovators, because every country is responding to the innovators that are their clients. So that's the first thing. The second thing, of course, is since in your question, you've got a Delaware company, then the other question is who is filing for the IP right? Is it the holding company or is it the local operating entity? Right? So if it's the local operating entity who is filing for the IP right in Ghana, you're going to get a Ghanaian patent. If you are asserting copyright in your software, you're going to be asserting a Ghanaian copyright. All right? If you want to take your Ghanaian copyright or your Ghanaian patent and enforce it, say, for example, in Germany, you would have to be doing so only by virtue of having obtained a German copyright for the same invention, for the same creativity, or a German patent for the same invention. In other words, there is a way legally in litigation where you can say, I have a patent in Ghana, and somebody in the US is essentially infringing my patent. But the question of whether or not that patent is valid for US purposes or for German purposes is always going to be an issue in that litigation, which is why most companies, when they are multinational in operation, will get IP rights in the countries where they think their innovation is most at risk for infringement. You obviously don't want to spend resources getting a patent in every country in the world. So you have to be strategic, or getting a copyright in every country of the world. You want to be strategic about how you decide what countries you want to get your IP protection secured. The other thing that you should note is choice of law issues matter. Certainly, every country can recognize the copyright that Ghana confers on your software program. But to do so is going to be dependent on the choice of law regime in that particular country. Now, I will tell you, that having been in IP for most of my life now, that our choice of law jurisprudence in sub-Saharan Africa is little to nothing, which means if you are operating in sub-Saharan Africa, from South Africa all the way to Ghana and Chad and Niger, if you're operating in any of these countries, you want to get a national IP right, because you can't rely on choice of law to protect the IP right that you obtained in the US or the IP right that you obtained in Germany. Okay, so that's a really important thing. The last thing that I will say is that with respect to trademarks other than the United States, trademarks operate on a registration system. So you have to go register your trademark, and that's a fairly easy process. In the US, you have to use it first before you register, and before you can own it. There's a little exception to that rule where you can register for a given period of time and then use it and then own it. But for the vast majority of the world, you can register the trademark, and then, of course, the trademark belongs to you, but then you have to enforce and secure that trademark on the internet, and you have to do it in local markets. So many African innovators are not taking advantage of recognizing the capacity of brands as a protection mechanism, as opposed to, say, patents or copyrights. They're cheaper, they're faster, and remember, everybody's buying something from you or using your services online. So it's important to create your brand image. And we're in a season of the world where African innovators, I think, have huge opportunity to establish a brand presence and to cultivate consumer goodwill. Last but not least, get a good lawyer to help you get your rights in whatever country you are operating in. You should know that in the United States, an application for a patent requires the name of the inventor. Not everybody has that requirement. So it's not just your company name that is at issue. In the United States, to get a patent, the name of the inventor actually must be on the patent application. Not every country requires that. So you want to think about strategically, where does it make sense for me to get my IP rights? Where is my innovation likely to be at risk? And where am I likely to get investors for the kind of innovation that I have? If your investors are going to be from Germany, then it may make sense for you to think about getting either a Japanese or a US or a German IP interest, because obviously investors in the northern part of the world are going to be looking for security, and they're going to look for security that they can enforce. And your Ghanaian patent or your Ghanaian copyright or your Ghanaian trademark may not give them that security. I told Techie and everyone that was the last comment, but I'm just going to put a footnote to this. Contracts are very important. I see too many African innovators who are not reading the contracts that they are signing. And what happens is, even if you get your Ghanaian IP right, you may be signing a contract that requires you to do any litigation in Japan or any litigation in Trinidad and Tobago. And so the virtue of being a Ghanaian innovator or a Nigerian innovator or a Senegalese innovator, you lose some of that if you agree by contract to litigate and to adjudicate or to arbitrate all of your issues in another country whose laws you don't know, and your lawyers may not be licensed there. So there's a really strong connection between innovation and IP and contracts. And it's very important for innovators to pay attention to
that. Dorothy, what are your reactions to? Yes, Dorothy, we seem to be getting some feedback from you. I don't know whether you have two devices
Really?
on.
Okay.
So if you do, kindly switch the other one off.
No, I don't actually. I don't know
Okay, now I
Are you
can
okay
hear
now?
you. Yes, so you can
All
please
right.
react to the question.
Say I told when I an adult, there is no treaty to do that. What the same treaty have protection members. But then the issue is that say mention that to look at the country's same treaty. That it is the law of the treaty of the jurisdiction within that covers you. So if you to an international and you're a Ghanaian and you want to protect in say Nigeria, so it's laws of that jurisdiction that protects you. If years after for the law will protect in Ghana. If you're saying that too contract, I want to say on that. The challenge we have here, people don't even know contract. Situations, circumstances where people do people may rise is the other of having to be a situation where there's no or to stay they are sign contracts to transactions. I keep telling when you distrust the other into a distrust the other person or you think that they, but it only shows about what you have clear terms. You need to go on is this one it's easier to resolve when they are. So I just want to say so that when you're getting into some kind of agreement property is concerned, put in that you are guided in the operations of the agreement.
Thank you so much, Dorothy.
There was a question I want to build on something Dorothy said for the question about the Google and the Amazon builders. So one of the things that you should know for whoever asked this question in the software space, if you're building on a platform, you've already signed a contract with Google and Amazon. So you might want to check the terms for your access and use of that platform, because that will define what happens to anything you innovate on top of those platforms. This is a really important thing. And I'm very concerned that the local Ghanaian, Bar Association, Nigerian Bar, so all of the local associations of lawyers are not really providing, and even law schools may not be helping our techpreneurs understand the consequences of building on these platforms. And I want to issue a challenge to all of you software builders in the audience that, I'm pretty sure that you can do better than Google or Amazon. I'm pretty sure that you can build these platforms too that will scale and that will respond to the particular infrastructural constraints that Africa has. Bandwidth problems and loadability problems and constant outages. And I just really want to say that even though you're not often recognized for the brilliance and the contributions you bring to the technology space, that you are very much needed. And that we are in a dispensation where African innovators, I believe, are going to be crucial to solving many of the world's pressing problems. So read what if you want to stay with Google and Amazon, and I love them, those are great companies, but read what you are joining yourself with.
Thank you. Thank you so much. I just want to remind all our participants that the polls are still on. You need to take it to be able to view the results. So kindly go ahead and look at the polls. There's still a few questions that are out there. I believe, Dorothy, this is more for you. It says that what is the process of applying for a patent in Ghana? Which office is in charge and how do we initiate the process?
So a patent application in Ghana undertaken office. General set up an office in the Ministry of Development, yes. And I don't know if you're asking this question. Then they are.
I believe they are.
Parliament House. Okay, so they are around the Parliament on to GJ or on is so they're on the Ghana. So that's where is that you approach the office. Take not to this your you approach the office, of course. Your prior so approach the office and you make but I think you need assist you on this. So you may want to get a patent lawyer who will assist you draft the patent application and all of. I think have I covered the question?
Yes, I think, thank you very much. That is very scary. You have to keep your idea in your head and then walk to a lawyer or the patent office before you disclose it. I guess that's the advice. So we'll see how best we can do that. It's easier said than done. So the other question says, my company is registered in New York. We invest and work with companies in Africa, currently Swaziland and South Africa. How can I leverage on our legal rights being a US-based company operating in Africa? So I believe, Prof, you may be helpful in helping him navigate this landscape.
So I don't know what you mean by leverage. So the one thing, and I think Dorothy will speak to this, the one thing you want to be really careful about is that many intellectual property offices in Africa are not appreciative of efforts to insist that an IP right obtained outside of those countries must somehow be superior to or take the place of a national IP right in South Africa or Swaziland. So I've been involved in both those countries, Swaziland and South Africa. And South Africa, as many of you may or may not know, has recently launched a patent examination office. So to obtain rights in South Africa, you now can go through a full examination process to obtain your patents or your copyright or your trademarks. It's not perfect, but it's available. And so it's something you want to do. Now, I will tell you that legally, based on the international treaties, what having IP rights outside of South Africa and Swaziland will do for you is both of these countries are members of the WTO. So both of them have signed up to the leading intellectual property treaties. That means that your right in the US or the UK or elsewhere, at least in the field of patent law, is entitled to something called a priority based on certain conditions. The fact that you've already obtained a patent or particularly a patent in another WTO country or another Paris Union country will give you a priority over a competing application at the national level. So I want everyone to hear me now. If you got your patent in South Africa and you want to obtain protection in the US, and there's someone else who has invented the exact same thing in the US, the intellectual property system is fundamentally based on first come, first get. And in the patent field, you cannot get two patents on the exact same innovation. So if you are concerned about being sort of pushed out of the field, you get your IP rights, say in South Africa, within the rules of the treaty that all WTO members are party to. You have priority if you file for a patent in another WTO or Paris Convention country within a certain time, etc. So you want, and this is also true, by the way, for trademarks, because in case you don't know, many, my mom was born in Ghana, in Kumasi, and so I'm always chuckling because, many Ghanaian, Nigerian, Senegalese names in particular and designs are being registered as trademarks outside of these countries. And sometimes, somebody's trying to register fufu as a trademark. I'm just like, why? Now, this is important because what happens is, fufu, there's actually a Nigerian software developer in Stanford who names all of his servers after all of the Ashanti gods, and after all the Yoruba gods, right? And that's how he names his servers. So I say that to say that when people are looking for trademarks, English is kind of a boring language. So people are looking, especially in this day and age, when you're trying to get people's attention. So people are looking to Ashanti names and figures. They're looking to Senegalese. They're looking to Yoruba. They're looking to all of these different rich African cultures. And so before you know it, you may want to name your software program, I don't know, Aquaba. Right? And before you know it, somebody has already trademarked that in the US, and there's nothing the Ghanaian government can do about it. So I think it's very, very important. Number one, this is why it's important for us to have laws on the books, because there are certain things that Ghana, Nigeria, South Africa, Swaziland, there's certain things that we can do at the national level to limit the possibility that someone is going to take something that is maybe culturally sensitive, maybe spiritually sensitive, and go register it as a commercial thing. So that's number one. We need to look at these laws and make sure they work for the digital environment. But the second thing is you need to be aware of what the laws say. And maybe Techie and her group, maybe in combination with another group, maybe they can offer some practical training for entrepreneurs and techpreneurs when it comes to navigating the global landscape. Because you have a priority right, and you may need to know that that priority window is very small. And there are certain things you cannot do in that priority window that if you do, you will lose your IP outside of Ghana. So all of these things are really important for you to know in terms of leveraging your US kind of headquarteredness for purposes of getting IP rights in South Africa or in Swaziland. That is a really, really important thing to note. Someone asked about the privacy concerns and how do you balance this? Again, balancing, I always say to my students that balancing is not a state of persistent position. When you're balancing, you're always balancing. If you're on a seesaw, somebody's up, somebody's down, but if you want to balance, you both have to be working to balance it. So the question of balance is case by case. It is sector by sector. I know that Ghana, for example, there's a public-private partnership in Ghana between the government and the telecom companies. I think it's Margins in Ghana. Basically, this is a public-private partnership that is going to profit from data that has been given by Ghanaian citizens. So how are you going to balance when the government has entered into this partnership with Infotech, which is a Latvian company? How are you going to? Well, that means somebody's going to read the laws of Latvia. Somebody's got to read the laws, right, of the UK and figure out, my goodness, I'm a Ghanaian. What are they doing with my data in Latvia, right? And you've got to understand what balance looks like. And then the citizens of Ghana are going to have to ask for some kind of transparency, reform, or something like that. But these things of balance happen case by case, sector by sector. It's really interesting. Of course, you know that in Nigeria, there was a breach of a database. There was a security breach, electronic health records. And this is, of course, very important now. And so, again, how do you balance? It's good to have the records electronically, but how do you balance that against security? And I think part of what we have to do is to make sure that we're holding governments accountable. That means lawyers, people like Techie and Africa Digital Rights Hub have to be at the top of their game, motivating, encouraging, building capacity, training, and educating both the public and the private sector about the status quo today.
Thank you so much. Dorothy, do you want to react to that? And I must say that we have about 32 minutes to go. There's still a lot of questions coming in. If you have still not responded to the polls, kindly go to it and respond. It wouldn't take you more than 5 minutes to react to the questions. Dorothy, do you want to react to that issue of registering in multiple jurisdictions?
Much a reaction is agree with Techie on and say that it's like you would have national laws within which you seek to enjoy the protection. Also, that in one protection within you want your so that you do not waste resources or not exploit it so also for you mentioned creating their own platform available public in them to get the technology so that they can make to create new and register. We want to take advantage of because the information is actually put out to the public. One who access to develop on a development and be registered as in other and remuneration from thank you.
So we have another question, Prof. There seems to be a lot of follow-up on registering patents, particularly in the US. I don't know why the interest in registering patents in the US, but a question that says that is it possible for a Ghanaian inventor to get a patent in another country, example the US? And then secondly, if the invention in question is online, for example, and sits on servers in the target country, in this case the US, even though the owner is Ghanaian, how does it affect the patentability of the invention?
Repeat the thing about the servers. I didn't catch you.
Okay, so he's saying that secondly, if the invention in question is online and, for example, sits on servers in the target country, which is US, Even though the owner is Ghanaian, how does that affect the patentability of the invention?
Okay, again, this is not legal advice, but I will tell you what I tell my students. So first of all, yes, absolutely. A Ghanaian can obtain a patent in the US, and there are actually many Ghanaians that have already obtained patents in the US, so you should know that. Second, it doesn't matter if it's a digital innovation. It's not relevant where it is sitting for purposes of patentability. It might matter for purposes of allegations of infringement and, you know, where you might have the case litigated. Jurisdictional questions may be influenced by where a server is located, but for patentability of the innovation, that's not really a concern. Now, your question, your subsidiary question is whether or not somehow having it digital affects patentability. And all I will say is you want to be careful that if you're under most laws, I don't know the Ghanaian jurisprudence. I have not seen any case out of the Ghanaian High Court on this question. So my guess would be that there is no law in Ghana on this question. But in many countries, if you disclose an innovation and you do not file for the patent within a given period of time, you will exclude yourself from patentability, because the patent system is meant to encourage you to disclose it for purposes of patentability. And if you disclose it and then, you know, 2 years later, after people have started using it, you come back and say, you know, I want my patent, the answer will be no. So to the extent that your question is about, I'm exposing my innovation, maybe I'm offering it for sale, maybe I am shopping it around. If you're exposing it to the public, there are risks associated with that in virtually every country that has jurisprudence on this question. There are risks because the patent system is not designed as a got you system. It's designed as a quid pro quo. We tell the public and we give you a monopoly right. And so if you start kind of fooling around with your invention after it has been completed and you have not filed for a patent, then you risk your patent eligibility. Now, let me also say that getting a patent is expensive. Getting a patent is time consuming. I know everybody likes to say, well, the Ghanaian Patent Office is terrible, the Nigerian Patent Office is terrible, and they may be terrible, but that's not the point. It's actually costly and expensive and time consuming everywhere. That is the nature of the patent system. The US has just in the last 3-4 years started to multiply patent offices in different parts of the country to try to get rid of the backlog. We had a tremendous backlog, and that's also for copyright registration, tremendous backlog. So this is really important. Now, I am really anticipating, and I've been working somewhat with some African governments who've been wanting to digitize their IP offices in order to help expedite the application process. And I've been designing and consulting and sort of trying to help governments think about this, because this is going to really be the next frontier for African IP offices. And so that's going to be helpful when that happens. And so what is critical for you is to ensure that you are taking advantage of what the law requires. And sometimes you can use contracts. Because until we have a system that is very fast, the nature of digital innovation is such that it is very easy to copy, and the next generation of it is coming out very quickly. So a patent takes on average, in any country, takes on average 14 to 36 months at a minimum. So that's 3 years. How many software programs are expired in 18 months, right? So you want to kind of think about how sustainable is your innovation? Is it innovation that you want to maximize the revenue you make in the next 6 months and then move on to the next thing? What's your business model, et cetera? So those are going to make a difference as to whether or not you get a patent. So look at the nature of the technology. If you're going to get a patent, as a lot of code, there's a lot of patent for source code. If you're going to get a patent, make sure it's because it is sincerely worth the investment, and make sure that you are doing everything you can to protect it during the patent application process.
Prof. There are a few other questions that I'll circle back to you, Dorothy and Prof. The question is that, is there a universal for innovation? When your product overlaps with another innovation, and I think this is a follow-up to that same question. It says, how much of your technology is allowed to overlap with some other technology to claim ownership? So I don't know, Dorothy, whether you would start reacting to that, and then Prof can come in.
Okay. Like I said earlier, are available for access to the public. I don't know if the addition or the improvement, it has to be new. You see, it must be something that really adds the already existing patent for you to be able to enjoy protection or ownership of. Just something minimal. It can't be something just minimal. A better way of doing, not just an alternative way of doing, but necessarily something major, not too major, but something substantial, so that it can be distinguished, the clearly seen or obvious to a person who is enlightened or educated in that same field of operation. I don't know if you don't think I'm communicating, but I think the innovation should be substantially clear, obvious, has been already exists. Protection for. Would you want to help me on this?
So I think a couple of things. Dorothy is obviously correct. Let me just say that what's really important to note, to go back to something Dorothy and I have both emphasized, is jurisdiction. IP is all about territoriality. It's about where you are and whether your invention satisfies the requirements of the country in which you are seeking protection. That is really fundamental. And I think to the extent that the invention has not been patented elsewhere. So when you get a patent, you get a Ghanaian patent, which means nobody can infringe the patent in Ghana. But someone can go to South Africa and infringe the patent there. So, be real clear about that. And which is why I said earlier, you want to identify the countries that are important to you and the countries that are the most likely to pose a risk to you. So, for example, I talk with many tech companies and I advise many tech companies who immediately they get their US filing done, they want to file in China. Not because they want to sell in China, but because they know that if they sell the product in China, there's a high likelihood that that product is going to end up being made in China. So now most American tech companies have had to become extremely proficient in Chinese patent law. And the Chinese government has responded with a specialized patent court, a specialized intellectual property court, specialized training for their judges, et cetera, et cetera. So this is something that I think Africa is going to have to think about, quite closely. And is there a universal threshold? The answer is no. There's a universal standard, which, as I said before, is the standard that is in the treaty. But I can give you many examples, maybe on a different talk and a different day, of inventions that were recognized as valid in the US and not recognized in Europe. Some of you, I'm sure many of you own iPhones. You'll remember that there was a very famous, just recently died down conflict between Samsung and Apple over a patent, a design patent for the iPhone. And Samsung won in some countries and Apple won in some countries. So that just goes to show you that, it's not uniform. So is it universal? Yes, as a standard. Is it uniform? No, not in practice.
Thank you so much, Prof. I just want to, those that have not responded to the polls, we have over 100 participants joining us. Interestingly, I think less than 20% of us have responded to the polls. So kindly go to it. But meanwhile, I will be, bringing out some of the reactions we're getting from the polls. The first question is, does your country have IP laws? 18% said they don't know. 7% said no. And 75% of those that have responded said they do. Do you know and understand how IP laws work in your country? We didn't have any non-applicable responses. 56% said no, and then 44% said yes. So I think, Prof, that really highlights a lot of the things that you brought up earlier. In your view, how for a techpreneur to understand how to protect their IP? 93% see it as very important, and then 3% see it as important. Then we have 3% saying they don't know. There were no, so everyone essentially sees, that it's very important for a technology entrepreneur to understand how to protect their IP. Then we had the question, have you or your business protected any of its IP? This we have 69% saying no, and I think, Prof, again, that highlights some of the issues that you raised earlier about, the innovators in Africa and how much less we, attempt to protect our innovations. And only 31% of those that have responded to the polls responded with a yes. Have you made an application to obtain an IP protection outside your country? 85% said no, and then 86, so people are still responding to the polls. So 86% said no, and then 14% said yes. Have you or your business been involved in an IP dispute? Only 11% said yes, 75% said no, and then 14% said they don't know. Where do you expect to get your IP advice? 7% said IP office. 11% said they would go to a government department or agency. 57% said they would go to their lawyers. And then 7% said they would use their professional communities or bodies to get that advice. 7% will go to any other form, and then 11% said they do not know. How would you rate your country's performance at protecting IP? 4% said very good, 18% said good, 39% said average, and then 21% said poor, and 7% said very poor, and 11% did not find it applicable. Have you, how would you describe the process of registering an IP in your country? Interestingly, 14% said it's very difficult, 50% don't know, 0% said it's easy, 4% said it's easy, it's very easy, 4% said it's easy, and then 25% say it's moderately easy, and 7% find it very difficult, and 14% find it difficult. What do you consider to be the most important challenge to the protection of IP? And I think this is very interesting. 74% of those that have responded to the polls are saying that the lack of awareness concerning IP laws seems to be the biggest challenge to IP protection, which confirms what all of you have said. 4% said it's expensive to register expensive IP registration process. 4% also said cumbersome IP registration process. And then 19% see the weak enforcement of laws and policies as the challenge. And we will still advise you to continue to respond to the poll. Conclude this. We will try and share the results for those that registered with Prof. That we're recording the sessions, and so within a week or so we'll get the videos prepped up and ready and uploaded on our websites, and so we'll notify you when that is done, so that you will have, I know a lot has gone on today, and we'll definitely have to go back and, you know, make sure that we intact to follow up with some of the discussions. At this point, I think I would want to give our panelists the opportunity to give remarks. Seeing one other question that has come in. It's saying, apologies if this might have been covered earlier, but one of the key questions that we have regarding hardly got clarity around patency for software and digital innovations. What is actually patentable? Is it the source code, or the product design flow, or the business module, or other attributes? Case in point would be taxi hailing apps like Lyft, Bolt, and Uber. So they just want to know which, you know, what protect software innovations and other digital innovations. I think that when you respond to this question as well, you can also use the opportunity to give us your concluding remarks. Dorothy, do you want to react to that?
Sure. Current. So we take the we register. They are available in sure that and already exists. Not the source code that we register. The source code probably industrial property of it, but we in that not every protection system or available process so that it so if registering a patent, right, as well, creations that can be IP, some that can be concurrently registered both in industrial property as well. So industrial is too expensive. Some you wait for the patent or the aspect of the registration so that you are not disadvantaged in your protection sphere. That I would like that softwares we do register the software themselves, not the business model, the source code design with design. So also, so different aspects are registered of intellectual property within some can fall in dual, they all have their spare. Ruth?
Dorothy, are you going to give, I can't hear her. Techie?
Okay,
you're back on. I can hear you now. Was Dorothy going to give closing remarks as well?
Sorry, say that again.
Okay. Is Dorothy giving closing remarks?
I think when we finish, she just finished. So,
okay, great.
Yeah, so Prof, if you
Well, I'm lip reading because you're fading in and out, but I figured what you were saying. I can hear you now.
Okay.
I think the video is just lagging, so that's fine. Dorothy answered it. I think this is a very complex question. I would encourage you to, as Dorothy has mentioned, one big takeaway from this session is that certainly with software, but also with many other products, you're not limited to just one IP regime. You have to evaluate both your market strategy and also the areas where you are most concerned to decide whether or not you are going to obtain a patent over your program or you're going to pursue copyright protection. I will tell you the copyright protection for software is really minimal. You don't get a lot out of your copyright. So if you really want protection for your software program, you want to look into the patentability of it. And I will also tell you, teaching in this area, that IP protection, patent protection for software is all over the place. You will get very different results in Europe from what you'll get in the US. And at the moment, this is not just in terms of the registration, this is in terms of court actions. So the IP office may think, okay, this is patentable, okay, this is copyrightable, but the test of any legal right is what a court is going to do with it. And when the courts get their hand on IP software issues, it's like making eggs. There's no head or tail to it. So you need to be really aware of that. When you get a patent for a computer program in the EU, it is a very strong patent. We refer to those kinds of patents as gold standard patents, actually. They're software patents in the EU are really quite solid. We are waiting in the US for a decision from the US Supreme Court on a copyright software case in a very huge battle between Oracle and Google. And when that decision is out, I will have a much better answer from the US side as to what is now protectable under copyright in the United States. So far, it's not clear to us what the court will say and if Google has a defense. This is Oracle suing Google. Oracle won at the Federal Circuit and Google has appealed it to the Supreme Court. The Supreme Court has taken cert and we thought they would rule before their recess, but clearly they're not going to do that. So many of the battles over IP and software are fought by the major tech companies, and then those decisions shape the industry. I think it's very important in the digital economy for African software coders and software programmers to begin really thinking about what you need to not just be passive recipients of software platforms, but to be actively engaged. You may want Oracle to win, you may want Google to win, who knows? But the idea is to encourage you to build platforms that make sense and that you can better control for the African space. Thank you so much. It was a joy and a pleasure.
Wow, this we really need to have a part 2 to this. It's been exciting. There's been a lot to digest. I'm sure that our community of participants have more questions for our panelists. So, Prof and then Dorothy, please, I will come back to you. There has to be a part 2 to this because we have more questions. And thank you to all our 100+ participants that joined from all over the world. Today we had people from Canada, Ireland, United Kingdom, Portugal, Ghana, Kenya, South Africa, India, Netherlands, USA, and Rwanda. Please remember to follow Africa Digital Rights on our social media pages to know of any of the will be coming up. But thank you so much, Prof. This has been amazing. I have taken so much notes here, and I'm going back to the drawing boards, especially on the whole issue around privacy and data protection and IP. I think I love that kind of marriage, and I'm looking forward to having more conversations around these issues. Thank you, Dorothy, for making time to connect with us again. And for those that joined from all over the world, I just want to say thank you so much for joining us for the past 2 hours. Without you, this would not have been possible. We've recorded the version, and so we'll be reaching out to you via the respective emails you used in registering for the program, and we'll share with you the PowerPoint presentations as well as the videos when they're ready. Thank you, and bye-bye for now. Thank you, everyone. Bye.